Polity Current Affairs through Static Class 2 Internal Democracy in Political Parties। भारत में पॉलिटिकल सिस्टम एंड पॉलिटिकल स्ट्रक्चर डेमोक्रेटिक है, लेकिन अभी ये डिमांड उठ रही है कि पॉलिटिकल पार्टीज़ के अंदर भी डेमोक्रेसी होनी चाहिए। पार्टीज़ का डिसीजन मेकिंग सिस्टम डिसेंट्रलाइज होना चाहिए और पार्टीज़ का कैंडिडेट सिलेक्शन सिस्टम भी डेमोक्रेटिक होना चाहिए। अभी होता क्या है कि अगर कोई लीडर ज़्यादा स्ट्रॉन्ग हो जाता है पार्टी में, तो पार्टी के डिसीजंस के ऊपर उस लीडर की ज़्यादा कमांड होती है। तो कौन सा कैंडिडेट को किस कॉन्स्टिट्यूएंसी से सेलेक्ट करना है, वो उस लीडर की सहमति के बिना डिसाइड नहीं किया जाता। और वो लीडर एक सेलिब्रिटी फिगर हो जाता है पार्टी के अंदर। तो किसी भी इलेक्शन में जो कोर मुद्दे हैं, जो कोर इश्यूज़ हैं, जो कॉन्स्टिट्यूएंसी के लोगों को मैटर करते हैं, वो ओवरशैडो हो जाते हैं बाय द इमेज ऑफ दैट इन्फ्लुएंशियल लीडर। So it is very necessary to ensure democracy in political parties also. UPSC can ask a question related to political party. It will not go into how many seats were won by which party or what is the election symbol of which party. It will simply ask the provisions related to the political parties which are in relation to elections. Such provisions are the qualifications for any party to become a national party and a state party. Let's see what are these qualifications. ये क्वालिफिकेशंस हैं, यदि किसी पार्टी को नेशनल पार्टी बनना है तो उसके लिए वो पार्टी 4 या उससे ज़्यादा स्टेट में एज ए स्टेट पार्टी रिकॉग्नाइज की जानी चाहिए बाय इलेक्शन कमीशन ऑफ इंडिया। इलेक्शन कमीशन ऑफ इंडिया रिकॉग्नाइजेज एनी पार्टी आइदर ए नेशनल पार्टी और ए स्टेट पार्टी। It is done by Election Commission of India upon fulfillment of certain conditions by the party. So to become a national party, first qualification is the party should be recognized as a state party in either 4 states or more than 4 states, or a party must secure 6% valid votes in at least 4 states in the previous Lok Sabha election or the state legislative assembly elections, and it must secure 4 member of parliament seats in the last Lok Sabha polls, or the party must secure 2% of Lok Sabha seats in at least 3 states. If any party fulfills any of these requirements, then that party can be recognized by Election Commission of India as national party. Currently, there are 6 national parties in India and 58 state recognized parties. What is the qualification to become a state recognized party? If any party fulfills any one of requirements, either this, either this, either this, or this, or this, then the party becomes a state party. If the party secures 6% votes in state legislative assembly elections and it secures along with that 2 state legislative assembly seats, or the party secures 2% votes in the last Lok Sabha election and 1 Lok Sabha seat from the same state, or the party secures 3% votes in state legislative assembly or 3 seats in state legislative assembly, or the party secures 8% votes either in state legislative assembly or Lok Sabha, or it secure 1 seat in the Lok Sabha for every 25 seats or any fraction thereof allotted to the state at a general election to the Lok Sabha from the state concerned. Suppose a state is allotted 100 seats, so it must has the party must secure 4 seats in Lok Sabha elections from the state. You can memorize these requirements by simply writing down the numerical codes. You can memorize these numerical codes to identify the numbers in the exam. If you are unable to remember the requirements or the qualifications for the political parties. What are the privileges of a recognized party? If a party is recognized either a national party or a state party, it is entitled to certain privileges, which are allocation of the party symbol. The party gets a permanent party symbol which cannot be allocated to any other candidate or any other party. Suppose BJP has Kamal or lotus flower. Congress has a symbol of hand on a tricolor. The party gets time for political broadcasts on the state-owned televisions and radio stations, and the party gets access to electoral rolls in free of cost. These electoral rolls are prepared by the Election Commission of India. The recognized party gets free access to these electoral rolls. The party can hire 40 star campaigners for campaigning in elections, whereas the registered unrecognized parties are allowed to have only 20 star campaigners. What is the significance of these star campaigners? First of all, these star campaigners has a particular image in society, and the expense of these star campaigners is not added to the expense of the candidate while campaigning. Let's discuss one question. Consider the following statement regarding the political parties in India. This question was asked in 2001. First statement is, the Representation of the People's Act 1951 provides for the registration of political parties. Suppose you do not remember what is given in 1951. Just read the question patiently. आराम से उस क्वेश्चन को पढ़िए, ठंडे दिमाग से फिर उसका आंसर निकालने की कोशिश कीजिए. Approach is very simple. Second statement is, we do not know about the first statement. Second statement is, registration of political parties is carried out by the Election Commission. We are sure that Election Commission registers the political parties, then this statement is correct. Okay, so let's identify among the options. Option A contains 2, it may be correct. Option C contains option 2, it might be correct. Option D contains option 2, it might be correct. Option B does not contain 2, but the statement 2 is a right statement, so we will eliminate option B. Now read third statement. A national level political party is one which is recognized in 4 or more states. We have read earlier that one of the qualification to be recognized as national party is that the party should be recognized as state party in 4 or more states. So the statement 3 is correct. Let's find out the answer. Which option contains statement 2 and 3? It is option D. So option D would be correct answer. See, while reading statement 4, during the 1999 general elections, there were 6 national and 48 national parties recognized by the Election Commission. We do not know about this statement 4, but we were able to find out the correct answer with the help of only statement 2 and statement 3. बस एक चीज़ चाहिए कि आप एग्ज़ाम पेपर में ठंडे दिमाग से सोचिए और पेशेंस के साथ काम लीजिए. Recently, There was very news about Election Commission of India. Many people blamed Election Commission of India for ignoring many irregularities in the last elections. So Election Commission of India becomes very important from the perspective of prelims exam. What are the constitutional provisions for the Election Commission? It is mentioned in the Constitution in Part 15 from Article 324 to 329. See, you have to read it multiple times so that you will get a rough idea about the range of the articles regarding various constitutional bodies, because such questions are asked in the exam. What is the nature of the Election Commission of India? It is a constitutional body because it is originally mentioned in the Constitution. How many members it carries? It is a multi-member body with 3 members. Originally, it has only one member, which was Chief Election Commissioner. But at present, it contains 3 members. One is Chief Election Commissioner and 2 other election commissioners. Chief Election Commissioner and election commissioners are appointed by the President. The tenure is for 6 years or 60 or till 65 years, whichever is earlier. The salary of the election commissioners is equal to the Supreme Court judge. Removal. Election commissioners can resign to Chief Election Commissioner, but the Chief Election Commissioner can resign to President. Election commissioners can be removed by the President on the recommendation of Chief Election Commissioner. But the removal of Chief Election Commissioner is similar to a Supreme Court judge, means Chief Election Commissioner can be removed only by way of impeachment by the Parliament. What is the constitutional limitation regarding ECI? The Constitution has not prescribed any qualification, whether it is legal, educational, administrative, or judicial, for the members of the Election Commission. The term of the members of the Election Commission is also not prescribed in the Constitution. The Constitution also does not debar the retiring election commissioners from any further appointment by the government. The appointment, tenure, qualifications are regulated under the Chief Election Commissioner and other election commissioners appointments and conditions of service and terms of office Act 2023. Earlier, recently it is amended. It is recently amended and it replaced the 1991 Act on the same matter. Responsibilities. The Election Commission of India conducts free and fair election for Lok Sabha, Rajya Sabha, state legislative assemblies, for the office of President, for the office of Vice President. It prepares electoral rolls. It registers and recognizes political parties. It allots symbols to parties and candidates. एक क्वेश्चन यहाँ पे पूछा जा सकता है कि यूपीएससी हो सकता है ये पूछ दे कि कॉन्स्टिट्यूशन प्रेस्क्राइब्स क्वालिफिकेशंस, टेन्योर, टर्म, etc., but you have to keep it in mind that the Constitution does not prescribe any such thing. One more thing to remember here is the Election Commission of India cannot deregister parties. We have seen many times about the model code of conduct. Model code of conduct are not backed by any law. They are just the rules or the codes developed by the Election Commission of India for smooth functioning of the election. Election Commission of India can take action for the violation of Representation of People Act. Let's discuss some questions. Which one of the following is correct in respect of the commencement of the election process in India? This question was asked in 1995. This question is still relevant in the present time. It is a very factual question, so you will have to memorize it. Its correct answer is C. The recommendation for election is made by the Election Commission and the notification for election is issued by President and governors of the states concerned. Let's discuss another question. The Dinesh Goswami committee was concerned with. This question is also relevant in present times. This committee was relevant with electoral reforms. This is also a factual question. Next question. If in an election to a state legislative assembly, the candidate who is declared elected loses his deposit, it means that. This question is also relevant in contemporary times. See, what is the meaning of losing a deposit? If a candidate fails to secure 1/6 votes, 1/6 votes polled votes in an election, then his deposit is considered to be forfeited. Every candidate who is trying to contest election for the Lok Sabha has to deposit 25,000 rupees, and for state legislative assembly he has to deposit 10,000 rupees, and for SC and ST candidates this amount is 12,500 rupees for Lok Sabha and 5,000 rupees for state legislative assembly. If the candidate fails to secure 1/6 polled votes in the election, then this deposit is considered to be forfeited. ये जो डिपॉजिट होता है ये जब्त कर लिया जाता है यदि वो कैंडिडेट टोटल पोल्ड वोट्स जो हैं उनका 1/6 वोट सिक्योर करने में फेल होता है। तो अब क्वेश्चन में क्या कह रहा है कि कैंडिडेट जो है वो declared elected, the candidate is declared elected and still he loses his deposit. What does it mean? See, the election in our country are based on the principle first past the post. It means the winning candidate has to secure just one more vote than the other candidates. Suppose there are candidates A, B and C and total votes are 120. Okay, so candidate A secures 40 votes, candidate B secures 39 votes, candidate C secures 41 votes, then candidate C will win. This is considered first past the post. Here total polled votes were 120. Suppose total votes in the constituent assembly or the constituency were 1200 votes, but only 120 votes were polled. टोटल वोट्स थे 1200 लेकिन सिर्फ 120 लोगों ने ही वोट डाला, तो तब भी कोई ना कोई कैंडिडेट जीता हुआ माना जाएगा। जिस भी कैंडिडेट के सबसे ज़्यादा वोट आएंगे वो कैंडिडेट जीता हुआ माना जाएगा। अगर कोई कैंडिडेट जीत गया है फिर भी उसका जो डिपॉजिट है वो जब्त हो गया है, फिर उसका क्या मीनिंग होगा? सपोज 120 वोट्स टोटल लोगों ने डाले लेकिन यहाँ पे 10 लोग, 10 नहीं 20 कैंडिडेट्स अगर यहाँ कंटेस्ट कर रहे होते तो हर एक कैंडिडेट को 1 वोट, किसी को 2 वोट, किसी को 6 वोट, किसी को 7 वोट्स, इस तरीके से मिलता। तो 1/6 इसका जो टोटल वोटिंग नंबर है वो 1/6 का 7.2 आता, सॉरी 7.2 नहीं, ये आता 20। अब अगर जो इलेक्टेड कैंडिडेट है उसके टोटल वोट्स हों 18, अब वो इलेक्टेड तो है, वो विनर तो है, लेकिन उसके टोटल वोट्स के 1/6 नंबर से टोटल वोट्स उसके कम हैं। तो इस केस में क्या होगा कि उसका जो डिपॉजिट होगा वो जब्त कर लिया जाएगा। तो इस कॉन्सेप्ट के हिसाब से यहाँ पे सही आंसर क्या होना चाहिए? स्टेटमेंट 1 इज द पोलिंग वाज वेरी पुअर। द स्टेटमेंट बी इज द इलेक्शन वाज फॉर मल्टी मेंबर कॉन्स्टिट्यूएंसी। The elected candidate's victory over here is nearest rival was very marginal. A very large number of candidates contested the election. This statement is correct. अगर नंबर ऑफ कैंडिडेट्स बहुत ज़्यादा होंगे तो पर कैंडिडेट जो वोट होगा वो बहुत ही कम हो जाएगा, भले ही कोई ना कोई कैंडिडेट उनमें से जीतेगा ही। नेक्स्ट क्वेश्चन, consider the following statements with reference to India. This question was asked in 2002 and this question is still relevant to the present time. First statement says Chief Election Commission and other election commissioners enjoy equal powers but receive unequal salaries. No, Chief Election Commissioner enjoy more power than other election commissioners and their salaries are also not equal. Chief Election Commissioner receives a somewhat more amount than other election commissioners. So this statement is incorrect. So just eliminate among the options. Option A contains 1, option C contains 1. So these options will be eliminated. Remaining options are B and D. Here 2 is in both options. So statement 2 seems to be correct. Let's read it. The Chief Election Commissioner is entitled to the same salary as is provided to a judge of the Supreme Court. We have read this earlier. This statement is correct. Now we have to decide between state number 3 and statement number 4. Just read statement number 4. The term of office of the election commissioner is 5 years from the date he assumes his office or till the day he attains the office of 62 years, whichever is earlier. No, the term is 6 years or 65 years, whichever is earlier. So here this statement is wrong. So option D is also eliminated. Remaining option is B. The correct answer is B. Panchayati Raj institutions. This topic is very important for the prelims exam as well as the mains exam. This topic was in news since in many states the elections to the panchayats were delayed by significant time. Let's discuss. What are the constitutional provisions? Under the 73rd Amendment Act, the Part 9 was added and 11th schedule was added, which were related to the panchayats. Under the 74th Constitutional Amendment Act, Part 9A was added and 12th schedule was added, which was related to the municipalities and the urban local bodies. What were the committees associated to the Panchayati Raj institutions? Just repeat it few more times. You will remember these committees in the prelims exam. These were Hanumant Rao Committee, G.V.K. Rao Committee, L.M. Singhvi Committee, Sarkaria Commission, Thungan Committee and Harlal Singh Kharra Committee. Such questions are asked in UPSC prelims exams, that which of the following committee is related to the Panchayati Raj institutions. Let's discuss now 73rd Amendment and its salient features. 73rd Constitutional Amendment added Part 9 to the Constitution, 11th Schedule to the Constitution and Article 243 to 243O, which contains various provisions related to panchayats. This part and these articles defined Gram Sabha and had provisions to establish Gram Sabha, defined panchayat a three-tier system at village, block and district level. 73rd Amendment Act also mandated setting up of a state election commission for conducting elections to the local bodies and a state finance commission to review and recommend finances to the local bodies. It also mandated to establish panchayats at the intermediate level, and it also has a provision that the panchayats at the intermediate level may not be constituted in a state having a population not exceeding 20 lakhs. यानी जिन स्टेट्स में 20 लाख से कम पॉपुलेशन है तो वहाँ पे इंटरमीडिएट एंड डिस्ट्रिक्ट लेवल पे पंचायत एस्टाब्लिश करना ज़रूरी नहीं है, केवल विलेजेस में एस्टाब्लिश करने से भी काम चल जाएगा. It also mentions about the qualification and disqualification of the candidates and the electors in the panchayat. Now let's discuss 74th Amendment and its salient features. 74th Amendment introduced Part 9A, 12th Schedule to the Constitution, and Article 243P to 243ZE, which contained provisions related to urban local bodies or municipalities. Municipalities are three types: Nagar Panchayats for areas in transition from rural area to urban area, municipal councils for smaller urban areas, municipal corporations for larger urban areas like Lucknow, Ghaziabad. Composition of local bodies are decided by the state legislatures. Provisions regarding how many ward members, how many members from which area, which area will be under the constituency. These matters are decided by the state legislature. Let's discuss what are the compulsory provisions and what are the voluntary provisions under the 73rd and 74th Amendment Act. These are important as questions related to these provisions are often asked in the prelims exam. What are the compulsory provisions? Constitution of Gram Sabha, establishment of panchayat at village, intermediate and district level, and also constitution of municipalities. Direct elections to all the stages, direct elections to all the offices which are mentioned above. Direct election to the post of the chairperson. For the post of chairperson, it recommends indirect election. 21 years to be the minimum age for contesting election in the panchayat. Reservation of seats for scheduled castes and scheduled tribes in panchayats at all levels. Reservation of 1/3 seats for women in panchayats at all levels. Fixing of tenure of 5 years and holding elections within 6 months before the expiration of the term. मीन्स जो पंचायत्स हैं उनका टेन्योर है 5 साल का और उनका जो टर्म एक्सपायरेशन डेट है उसके 6 महीने के अंदर अंदर इलेक्शंस फ्रेश पंचायत के लिए हो जाने चाहिए. इफ़ डिसोल्यूशन बिफोर 5 years, इलेक्शन ओनली फॉर द रिमाइंडर टर्म. यदि किसी पंचायत को डिसॉल्व कर दिया जाता है 5 साल का टर्म पूरा किए बिना, तो जो नया पंचायत के लिए जो इलेक्शन होगा वो पंचायत जो है रिमाइंडर जो टर्म है उसके लिए ही फंक्शन करेगी. सपोज किसी पंचायत को पहले 2 साल में ही डिसॉल्व कर दिया जाए तो रिमेनिंग जो 3 years हैं उसके लिए ही नई पंचायत का इलेक्शन किया जाएगा. इफ़ द रिमाइंडर टर्म इज़ लेस देन 6 months, then there is no need to conduct elections for the fresh panchayat. It will be conducted only after the 5th year term. Suppose a panchayat is dissolved in just 4.5 years or 4 years 6 months. सो कितना टर्म बचा? ओनली 6 मंथ्स का। तो इस 6 मंथ्स के लिए फ्रेश पंचायत इलेक्शन कंडक्ट कराने की कोई ज़रूरत नहीं है। ये 6 मंथ्स पूरे होने के बाद ही ये फ्रेश पंचायत के लिए इलेक्शन कराए जाएंगे। Establishment of State Election Commission, it is a mandatory provision. Constitution of State Finance Commission, every 5 years, it is also a mandatory provision. Division of Panchayat area into smaller units, it is also a mandatory provision under the 73rd and 74th Amendment. What are the voluntary provisions? Giving representation to members of the parliament and state legislature at various levels of the panchayat, providing reservation of seats for backward classes OBCs, granting powers and authority to Panchayati Raj institutions. See, पंचायती राज इंस्टीट्यूशन कौन सा टैक्स लगा सकते हैं, क्या क्या एक्टिविटी कर सकते हैं, क्या क्या उनकी रिस्पॉन्सिबिलिटीज़ होंगी, क्या उनके पास अथॉरिटी होगी, ये सब डिसाइड कौन करेगा? स्टेट लेजिस्लेचर. डेवोल्यूशन ऑफ पावर्स एंड रिप्रेजेंटेशन, ग्रांटिंग फाइनेंशियल पावर टू द पंचायत्स, these are also voluntary provisions. State can provide for representation of the members of the Council of States and the members of Legislative Council of the state where they are registered as electors within a panchayat area. Means state legislatures जो हैं वो जो लेजिस्लेटिव काउंसिल हैं स्टेट की उनके मेंबर्स के लिए, एमएलसीज के लिए, और जो राज्यसभा के मेंबर्स हैं उनके लिए पंचायत्स में डिफरेंट पोजीशंस पे रिप्रेजेंटेशन सिक्योर कर सकती हैं जहाँ पे वो जिस पंचायत एरिया में वो एज एन इलेक्टर रजिस्टर्ड हैं. The manner of election to the post of chairperson is to be decided by the state legislature. 11th and 12th schedules talk about the responsibilities and areas of work of local bodies. We have seen 73rd and 74th Amendment Acts inserted some articles and schedules. It inserted 11th schedule and 12th schedule. These 11th and 12th schedules talk about the responsibilities and the areas of work. Responsibilities and areas of work such as education, canal, etc. Let's discuss some questions. Question number 1. Which one of the following was not proposed by the 73rd Constitutional Amendment in the area of Panchayati Raj? This question was asked in 1997 and it is very much relevant in the present time also. Let's read the statements. Statement A. 30% seats in all elected rural local bodies will be reserved for women candidates at all levels. Before finding the answers, just make one practice. Just make one habit while reading the question. Mark the negative part, the not part, if any mentioned in the question. Here it is mentioned which one of the following was not proposed by the Constitutional Amendment Act. Here this not, you have to find out the negative, you have to find out the wrong statement among the 4 statements. So read first statement. 30% seats in all elected rural local bodies for women. Yes, this statement is correct. We have read earlier, this statement is correct. The states will constitute their finance commissions to allocate resources to Panchayati Raj institutions. Yes, this statement is also correct. The Panchayati Raj functionaries will be disqualified to hold their offices if they have more than 2 children. ये कैसा बेतुका स्टेटमेंट है? ये तो आंसर हो ही नहीं सकता, ये तो सही हो ही नहीं सकता कॉमन सेंस से भी. सो दिस स्टेटमेंट इज इनकरेक्ट एंड दिस विल बी आवर आंसर. Just read the fourth statement also. The elections will be held in 6 months' time if Panchayati Raj bodies are superseded or dissolved by the state government. Yes, this statement is correct. Next question. Given below are two statements, one labeled as assertion and the other labeled as reason. रिसेंटली ऐसे क्वेश्चंस फिर से इंट्रोड्यूस किए हैं यूपीएससी ने प्रीलिम्स एग्जाम में. असर्शन रीजन क्वेश्चन पहले पूछे जाया करते थे. असर्शन, व्हाट डज इट से? रिजर्वेशन ऑफ 33% ऑफ सीट्स फॉर women in parliament and state legislature does not require any constitutional amendment. This statement is wrong because you will have to amend Schedule 4 of the Constitution. So the constitutional amendment is required. So this statement is wrong. By identifying this wrong statement, you can find out the answer, which is D. Let's read reason also. Political parties contesting elections can allocate 33% of seats they contest to women candidates without any constitutional amendment. Yes, कोई भी पॉलिटिकल पार्टी 33% ऑफ द सीट्स वुमेन कैंडिडेट्स के लिए रिजर्व कर सकती है. ये उसको अधिकार है, उसके लिए किसी कॉन्स्टिट्यूशनल अमेंडमेंट की ज़रूरत नहीं है. इसके ऊपर किसी भी तरह का बार भी नहीं है, किसी भी तरह का बैन भी नहीं है. सी, असर्शन एंड रीजन वाले क्वेश्चंस बहुत ही इजी होते हैं. अगर असर्शन गलत है या रीजन गलत है तो ये क्वेश्चन बहुत ही इजी हो जाता है. लेट्स डिस्कस नेक्स्ट क्वेश्चन. The 73rd Constitutional Amendment Act 1992 refers to the, it was asked in 2000, it is also relevant in the present time. Option A, generation of gainful employment for the employed and the underemployed men and women in rural area. To many, this question may seem to be correct. Let's leave it for now. Read option B. You have to identify which option is most correct. जहाँ पे चारों ऑप्शन करेक्ट दिख रहे हो वहाँ आपको पता करना है कि कौन सा ऑप्शन ज़्यादा क्लोज है टू द क्वेश्चन आस्क्ड. लेट्स रीड ऑप्शन बी. जनरेशन ऑफ employment for the able-bodied adults who are in need and desirous of work during the lean agricultural season. This statement may seem to be correct to many people. Just read option C. Laying the foundation for strong and vibrant Panchayati Raj institutions in the country. Option D. Guarantee of right to life, liberty and security of person, equality before law and equal protection without discrimination. तो 73rd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट जो थे वो आए थे डेमोक्रेटिक डिसेंट्रलाइजेशन के लिए. और ये एसोसिएटेड है पंचायती राज इंस्टीट्यूशंस के लिए. पंचायती राज इंस्टीट्यूशंस. तो कौन सा ऑप्शन इनमें सबसे ज़्यादा सही है, सबसे ज़्यादा क्लोज है इसके? ऑप्शन सी, ऑब्वियसली ऑप्शन सी. लेइंग द फाउंडेशन फॉर स्ट्रॉन्ग एंड वाइब्रेंट पंचायती राज इंस्टीट्यूशंस इन द कंट्री. सो द राइट आंसर विल बी ऑप्शन सी. नेक्स्ट क्वेश्चन. Consider the following statements. Part 9 of the Constitution of India provisions for panchayats and was inserted by the Constitutional Amendment Act 1992. Yes, part 9 was inserted in, sorry, there is something missing in this question. It is 73rd. Yes, Part 9 of the Constitution of India, Provisions of the Panchayats, and was inserted by the 73rd Constitutional Amendment Act 1992. Part 9A of the Constitution of India contains provisions for municipalities. Yes, Part 9A contains provision for municipalities. And the Article 243Q envisages two types of municipalities, a municipal council and a municipal corporation for every state. See, here for every state it is not mandated. It is not mandated for every state, but panchayats are mandated for every state. So option 2 here is incorrect and option 1 is correct. So the answer will be option A. Let's discuss next question. Local self-government can be best explained as an exercise in. This question was asked in 2017 and this question is relevant in present time also. What is the meaning of, what is the purpose of local self-government? Is it federalism? It may be. Administrative delegation? No. Direct democracy? No. Direct democracy is altogether different thing. Democratic decentralization? Yes. Federalism does not relate very much to the local self-government. It can relate by far, but it is not very close. Democratic decentralization is very close in Indian context. So the correct option would be option B. Next topic is digital public infrastructure. This topic was in very much news in recently. So what is the meaning of digital public infrastructure? See, here two words are at play. First is digital, other is public infrastructure. What is the meaning of public infrastructure? Any infrastructure which is made for the public purpose, for the public use. If that infrastructure is digital, then it is digital public infrastructure. Normally, public infrastructure is parks, road, bridge. Okay, these infrastructure are made for public. Digital public infrastructures are the infrastructure which are digital, which are made for public service. Such infrastructures are digital identity systems such as Aadhaar, digital payment systems such as digital wallets, payment gateways like UPI, and banking platforms, digital services like online services provided by the government such as e-governance portals, public health information like e-Sanjeevani, and digital education platforms, data infrastructure, the systems for storing, managing, sharing data securely such as DigiLocker, cyber security frameworks, for example information security management systems. Public digital infrastructures are of two. First is foundational DPI. What is foundational DPI? Foundational DPI is that which is acting as the foundation for some other infrastructure. These are the basis for the digital frameworks encompassing realms of digital identity systems. For example, UPI. UPI is at the basis of various payment modes, various payment options. You have Paytm, you have Bharat Pay, you have Phone Pay. Each of these platform is based on UPI. So such infrastructures are foundational digital public infrastructures. Other is sectoral digital public infrastructure. These digital public infrastructures are related to particular sectors such as Ayushman Bharat Digital Mission. It is related to health sector. Here are some examples of India's digital public infrastructures. UPI, Aadhaar ecosystem, Open Network for Digital Commerce (ONDC), Account Aggregator Network, eSanjeevani, digital rupee, digital e-marketplace. A very simple question can be asked in UPSC asking what is the meaning of digital public infrastructure. It will give various options to confuse you, but you have to remember the simple definition and the simple meaning of digital public infrastructure. Next topic is Digital India Land Records Modernization Program. What is the meaning of it? नाम से ही पता चलता है, डिजिटल इंडिया लैंड रिकॉर्ड्स मॉडर्नाइजेशन प्रोग्राम। लैंड रिकॉर्ड्स को डिजिटल फॉर्म में मॉडर्नाइज करना है, उसके लिए जो प्रोग्राम है वो है डिजिटल इंडिया लैंड रिकॉर्ड्स मॉडर्नाइजेशन प्रोग्राम। अभी तक लैंड रिकॉर्ड्स जो थे वो हार्ड कॉपी एंड हैंड रिटन कॉपीज़ में मैनेज किए जाते थे। उसकी वजह से प्रॉब्लम क्या आती थी, कई बार डॉक्यूमेंट्स डिस्ट्रॉय हो जाते थे, आग लग गई, दिमक आ गया, पानी में ख़राब हो गए, या फिर कई बार डुप्लीकेट डॉक्यूमेंट्स भी लोग बना लेते थे, जिसकी वजह से लीगल डिस्प्यूट्स क्रिएट होते थे और कई तरह के प्रॉब्लम्स क्रिएट होती थी। जैसे अभी मान लो दो पर्सन है, पर्सन ए एंड पर्सन बी, इसने इसको लैंड बेचा। अब इन दोनों का एग्रीमेंट है, लेकिन ये डिजिटाइज फॉर्म में नहीं है, तो इसको सिर्फ ए और बी ही एक्सेस कर सकता है और गवर्नमेंट के पास जो कॉपी है उसको एक्सेस करना किसी थर्ड पर्सन के लिए इज़ ए वेरी क्यूम्बरसम टास्क, इट इज़ वेरी डिफ़िकल्ट टास्क। तो ए ने बी को लैंड बेच दिया। अब सेम लैंड पे ए ने सी के साथ भी कॉन्ट्रैक्ट कर लिया, इससे भी पैसे ले लिए। अब इस पार्सल ऑफ लैंड पे बी भी अपना हक जमा रहा है, सी भी अपना हक जता रहा है। अब इस ज़मीन के ऊपर होगा कोर्ट केस, कोर्ट लिटिगेशंस। तो इस तरह के डिस्प्यूट्स को रोकने के लिए, इस तरह के फ्रॉड्स को कम करने के लिए और लैंड एक्विजिशन एंड लैंड डीलिंग में एफिशिएंसी एंड ऑथेंटिसिटी लाने के लिए ये प्रोग्राम चलाया गया है। दिस प्रोग्राम is introduced by Ministry of Rural Development. What is the aim of this program? To replace the manual presumptive land titling system with a digital conclusive land titling system. See, what is the meaning of presumptive land titling system and digital conclusive land titling system? Presumptive land titling system में क्या होता है कि जो करेंटली लैंड को ऑक्यूपाई किए हुए है उसको लैंड का ओनर मान के चला जाता है। मान लीजिए दो पर्सन है ए और बी, इन दोनों ने, ए के पास ये क्लेम है कि ये लैंड मेरी हेरिटेज लैंड है क्योंकि ये मेरे फोर फादर से मुझको मिली है, लेकिन इस लैंड का जो डॉक्यूमेंटेशन है वो ए के फोर फादर्स के पास होगा। अब ए के पास इसका डॉक्यूमेंटेशन तो नहीं है क्योंकि ए को ये लैंड इनहेरिटेंस में मिली है, तो ए ने इस पे अपना हक जताते हुए ए लैंड का डीलिंग बी के साथ कर लिया। अब बी और ए के बीच में कोई पक्का डॉक्यूमेंटेशन नहीं है, यहाँ पर सिर्फ है सेल डीड्स। इनके बीच में एक सेल डीड साइन हुआ है जिसके बेसिस पे बी जो है, पर्सन बी जो है, इस लैंड पार्सल के ऊपर कहेगा कि आई एम द ओनर ऑफ दिस लैंड पार्सल, बट this system is presuming that B is the owner of this land parcel, but it cannot conclusively say that B is the owner of this land parcel. Suppose कहीं से ए का कोई दूर का चचेरा भाई सी आ जाए और कहे कि मेरे पास इस लैंड के डॉक्यूमेंट्स हैं, मैं इसका ओनर हूँ, इसका ओनर बी नहीं है। तो यहाँ पे क्या है कि कोर्ट लिटिगेशन में बहुत ज़्यादा प्रॉब्लम होती है लोगों को। तो इस सिस्टम से बचने के लिए कंक्लूसिव लैंड टाइटलिंग की ओर शिफ्ट किया जा रहा है। अब ये कंक्लूसिव लैंड टाइटलिंग सिस्टम क्या होगा? कंक्लूसिव लैंड टाइटलिंग सिस्टम होगा, सिंस ऑल ऑफ योर रिकॉर्ड्स आर डिजिटल देन इट कैन नॉट बी डिस्ट्रॉयड, इट इज स्टोर्ड फॉर एवर। सो अगर ए के पास कोई लैंड, ए इस लैंड पार्सल का ओनरशिप राइट है, तो ये डॉक्यूमेंट जो है डिजिटाइज फॉर्म में स्टोर किया जाएगा। अब इस डिजिटाइज डॉक्यूमेंट के बेसिस पे ये एस्टैब्लिश किया जा सकता है कि ए इज़ द ओनर ऑफ दिस लैंड पार्सल, देन ए कैन सेल दिस लैंड पार्सल टू एनी पर्सन बी and there will be no confusion. The ownership of this land parcel will be transferred to automatically to person B. So this is conclusive land titling system. It also seeks to computerize all revenue codes in the country, their integration with the land records. It seeks to computerize the revenue codes. Okay. Consent based linking of Aadhaar number with record of rights. Presumptive system requires a registration of sales deeds and not land titles. Conclusive land titling requires it provides a state guarantee of ownership which will aid in improving the transparency and accuracy of land records. Some related concepts: UL PIN, unique land parcel identification number. It is a 14-digit Aadhaar-like code, alphanumeric code. National Generic Document Registration System. It is e-registration of lands. Bhumi Samman Award for districts achieving implementation of this program. UPSC can ask a question on the basis of presumptive land titling, conclusive land titling, Digital India Land Record Modernization Program, Unique Land Parcel Identification Number means ULPIN, and this National Genetic Document Registration System. It is not genetic, it is generic. I will correct it in the PDF which I will upload on the Telegram channel. Bhumi Samman Award. Okay, here you can see a flow diagram regarding the things discussed above. It is Aadhaar linking, it is consent based, record of rights, computerization of revenue codes, conclusive land titling system for easy to memorize. Let's discuss the land reforms conducted in India. The land reforms were recommended by the J.C. Kumarappa Committee. Just remember this name. Land reforms encompass mainly 5 components: abolition of intermediary tenures such as zamindari, tenancy reforms to restrict illegal forceful eviction by the zamindars of the tenants, sealing of land holdings and distribution of surplus land, consolidation of holdings in which if various fragments of land were combined and the land was put under cultivation to ensure efficiency and productivity of the land parcel, and compilation and updating of land records. Here you can see it becomes easy to memorize while seeing the diagram. Persons with disability. Recently this topic was in news. What are the constitutional provisions related to persons with disability? There are various provisions. Some are mentioned in preamble like justice, social, economic and political, liberty, fundamental rights, Article 14 which provides right to equality, Article 19 which guarantees the right to freedom to move and express oneself, Article 21 ensures the right to live with dignity. DPSP under Article 41, it calls for public assistance in case of unemployment, old age, sickness and disablement. And also the responsibilities of panchayats and municipalities. 11th schedule, it mentions social welfare, including welfare of handicapped and mentally retarded. In the 12th schedule, it mentions safeguarding interest of weaker sections, including handicapped and mentally retarded. See, UPSC can ask question like which provision of the constitution is related to the welfare of the people with disabilities. So you can mark correct answer by referring to these provisions in the constitution. Next topic is census. Simple name is civil registration system. The Registration of Births and Deaths Act 1969 mandates that all births and deaths must be officially registered. So, if a question is asked whether registration of births and deaths is mandatory, then yes, it is mandatory. Some facts related to census. First, it was conducted in Banaras in 1824 by James Prinsep, but it was just for a city. First census was conducted in 1872 by Lord Mayo. Second census was conducted in 1881 by W.C. Plowden, who was Census Commissioner of India. Since 1881, censuses have been undertaken uninterruptedly once every 10 years. Only decrease in population in fifth census, which was carried out in 1921, we saw a decrease in population due to flu pandemic in 1918. The census year of 1921 is called the year of the Great Divide in the demographic history of India. Census is conducted by Registrar General and Census Commissioner of India under Home Secretary. Since latest census was to be conducted in 2021, its data has not been published till now, and this topic has been in news. Various politicians in the parliament raised the demand for publishing the data of census 2021. So this topic becomes very important from the perspective of upcoming prelims exam. Next topic is judiciary. This topic is very vast. I will make a separate video on this topic. Let's discuss now the topics which were in news recently. The High Court and Supreme Court. Senior most judge in the Supreme Court is appointed as CJI by convention since Justice Sanjeev Khanna is appointed CJI recently. The senior most judge in Supreme Court is appointed as CJI by convention except in 1964, 73 and 77. During these 3 years, this convention was not followed. Otherwise, senior most judge becomes CJI. The appointment of Supreme Court and High Court judge is done by the President. These judges are appointed by the President on the recommendation of a collegium. Let's discuss the evolution of collegium. For appointment, President must consult with judges of Supreme Court and High Court judges as he deems necessary. This provision is mentioned in Constitution. Okay, so the meaning of consultation was very debatable and there were various interpretations for this word consultation. So in first judge's case, the Supreme Court ruled that consultation does not mean concurrence. In the second judge's case, Supreme Court ruled that consultation means concurrence. The advice of CJI is binding, but CJI must consult two senior Supreme Court judges. And in third judge's case, Supreme Court ruled that the CGI must consult four senior most Supreme Court judges for advising the President on the appointment of judges to the Supreme Court and High Court. What is the removal? What is the procedure of removal of High Court and Supreme Court judges? The removal of High Court and Supreme Court judges is regulated by Judges Inquiry Act. The process is not given in the Constitution, only the provision is given in the Constitution. The process is regulated by Judges Inquiry Act. What is the step? Step 1. A motion signed by 100 members in Lok Sabha. If the motion is moved in Lok Sabha, then that must be signed by 100 Lok Sabha member of parliaments. And if that motion is moved in Rajya Sabha, then that motion must be signed by 50 members. Step 2. The speaker admits. If the speaker admits, then he or she will constitute a 3-member investigative committee, which will include CJI, Chief Justice of the High Court, distinguished jurist. Step 3. If this committee finds the judge guilty, then we come to step 4. Parliament in each house passes by special majority. This motion must be passed in each house of the parliament by special majority, which means 50% of the total votes and 2/3 votes of the present and voting. So, till now, no judge of a High Court or Supreme Court has been impeached so far. What are the grounds of removal? There are only two grounds: misbehavior and incapacity. I will include these in the PDF which I will upload on the Telegram. Let's discuss a question. Consider the following statements. This question was asked in 2007. The mode of removal of a judge of a High Court in India is same as that of removal of a judge of a Supreme Court. Yes, the manner is similar. After retirement from the office, a permanent judge of a High Court cannot plead or act in any court or before any authority in India. See, a High Court judge can plead in a Supreme Court, but a Supreme Court judge cannot plead in any court in India. So this statement is wrong. Option A is correct here. Next topic is Interstate Council. This topic was recently in news due to the GST Council. So it becomes important for the upcoming prelims exam. Interstate Council is a forum through which center and states coordinate with each other to resolve disputes and cooperate with each other for development. The Interstate Council was mentioned in Article 263 of the Constitution, but it was constituted in first through a presidential order in 1990 on the recommendation of Sarkaria Commission. What is the composition? It consists of a chairman who is Prime Minister. Its members are CM, Chief Ministers of all states, Chief Ministers of Union Territories having Legislative Assembly, and Administrators of Union Territories not having a Legislative Assembly, and 6 Ministers of Cabinet rank in Union Council of Ministers who are to be nominated by the Prime Minister. Here you can see the diagrams which will make easy for you to remember. What is the potential of Interstate Council? What is the purpose? Disaster management, public health, economic planning. So Interstate Council can be used for various purposes. Next topic is Zonal Council. Zonal Council is also a related topic to the Interstate Council. So let's discuss this. Zonal councils are not constitutional bodies, whereas Interstate Council was a constitutional body. Zonal councils are statutory bodies established under the States Reorganization Act of 1956. There are total 5 zonal councils, which are Northern, Central, Eastern, Western, and Southern. Their aim is to promote interstate cooperation and coordination, which is very similar to interstate council. Each zonal council is headed by Union Home Minister with CMs from the constituent states serving as vice chairpersons on a rotating basis. Suppose this is a zonal council, then its chairman will be Home Minister and its vice president will be the CMs of these states. The CMs of these states will on a rotational basis act as vice president. The northeastern region has a separate council. The northeastern region has a separate council, the Northeastern Council, which is named as the Northeastern Council. It was created in 1972. It was set up under the Northeastern Council Act 1972. So this was all for today. Polity class for November month is done. Thank you friends. Like and subscribe the channel and comment any suggestion if you have, and subscribe the Telegram channel mentioned in the description, upon which I will upload the PDF of this lecture. Thank you. Thank you very much. Keep revising, keep studying, stay motivated, stay healthy, and keep practicing previous year questions.